Rental property in an Illinois divorce. Diversification is a common investment strategy where holding a variety of assets can reduce risk and increase long-term returns. Many investors, in addition to owning stocks and bonds, also own real estate. Real estate investments come with benefits like the ability to borrow for purchase, tax-deductible loan interest, depreciation, and rental income. However, they also come with responsibilities such as maintenance, property taxes, and the complexity of selling the property. One significant challenge arises when dealing with rental property in the case of a divorce. Legalities of rental property in an Illinois divorce. The first step in addressing rental property during a divorce in Illinois is determining whether the property is marital or non-marital. According to Illinois law, non-marital property is not divisible in a divorce. If a piece of real estate is held in one person's name and determined to be non-marital, that person will retain sole ownership after the divorce. Conversely, marital property, which includes any property acquired during the marriage, with certain exceptions, must be divided equitably. Determining marital versus non-marital property. Non-marital property. Property acquired by gift, inheritance, or in exchange for such property remains non-marital. Income from non-marital property, unless attributed to the personal effort of a spouse, also remains non-marital. Marital property. Any property acquired during the marriage is typically considered marital property. This includes properties bought with marital funds or held jointly. If an inheritance or gift was put into both spouses' names, it becomes marital property. Even non-marital property that is commingled can be considered marital. Handling rental property in divorce. If a rental property is deemed marital, it must be divided. This involves determining the value of the property, which can be done through sale or professional appraisal. If one party wishes to keep the property, they may need to buy out the other party's share, potentially through a home equity loan. The rental income from the property must also be accounted for and divided as marital property. Income considerations. Rental income is included in the calculation of net income for child support and maintenance, alimony. Illinois law has specific guidelines for calculating net income, including deductions for necessary business expenses but excluding certain items like accelerated depreciation. Managing and keeping rental property post-divorce. During the divorce, both parties are bound by the terms of existing leases, but either party can decide to terminate the tenancy once the lease expires. After the divorce, the parties can choose to continue co-owning the property, potentially forming a corporation or LLC for shared ownership. This agreement should include specific buyout clauses to handle future decisions. Conclusion and contact information. Dealing with rental property during a divorce in Illinois involves complex legal considerations and significant financial decisions. It's essential to determine whether the property is marital or non-marital, accurately value the property, and account for rental income in calculations for child support and maintenance. For personalized guidance and to discuss your options, contact our experienced Chicago divorce attorneys. Reach out to us at 773-334-6311 or visit our office at 1165 North Clark Street, number 700, Chicago, Illinois, 60610, to ensure your interests are protected throughout the divorce process.